that's the question that was at the patent office. And so let me give you a concrete example. Let's see, claim 1. Okay, this was the patent that was litigated, and this is the system claim. So remember, the system claim is covering the components: the computer at home, the server computer on the internet, the computer at the airport, right? The company that's providing this service owns the server computer on the internet, the software running on that server computer, right? That's the service that they're providing. And they've also provided some software to the person who's accessing the computer at home, because it has to be able to accept the communication. And so that's what is being provided by the company who's providing this service. So in this case, let's say the patent owner has found some other people to sue who are providing the same service. Works the same way with the central locator server. And let's say they want to assert claim 1 against Citrix, for example. Citrix is Go to My PC. It's a very popular product. Many of you have probably used it. Citrix will say, wait a second, I don't provide A, the personal computer. I don't provide that. I do provide B, the locator server on the internet, but I don't provide C. C is the remote computer. That's the computer at the airport. It's the user who's doing all those things. The user has provided the home computer and the airport computer. And so Citrix will say, see, I'm not directly infringing this claim. There has to be a combination of people. There's a contributory or an inducement of infringement. And that's the issue with software patents in terms of the enforceability. Who are you, and specifically with services, if you have a software that covers a service, who is the real infringer? It's the person who's providing the service that's infringing the patent, not the end user necessarily. And these new cases have paved the way to enforce those software patents against the service provider without worrying about the individuals. So what they've said is, look, it's enough that the individuals perform those aspects. But the service provider, the person who's providing the underlying infringing technology to the patent, is the person who's liable. And a good patent, and I'm happy to say this is a good patent, takes that into consideration. So claim 1, you see, is divided up with the components, so that somebody could say, at least before before the rules changed, they could say, well, I don't provide the personal computer at home. I don't provide the airport computer that the person is traveling with, or iPad. So I don't infringe this patent claim. Well, that's fine, and that's why this patent covers many different things. It also covers, let's see, claim 20. Claim 20 covers, this is all the preamble, so comprising A, the locator server computer. And the rest of the language of this claim just describes what that locator server computer does. But you see, if you're suing Citrix, they are providing that locator server computer. You see, so this is a good patent because it's approaching the software and what the software does from all different angles. So whoever drafted this patent, it wasn't me, it wasn't my firm, did a really good job of thinking about what are the different angles at which somebody might infringe this service, this remote access service. And they thought to themselves, well, there's a problem because whoever's providing the service isn't providing those end computers, but they certainly will be providing the server computer on the internet. So why don't I have a patent claim that's directed to the server computer on the internet? And so that's what they did. So there's this claim 20 that provides for that. And claim 24 and 26, which I pointed out to you before, cover the software running on the personal computer and the software running on the locator server computer. Again, both of which would be provided by the infringing service provider, let's say Citrix. They would be providing that software. They're not providing the computers. The computers were covered in the system claim of claim 1. They're providing the software that's running on those computers, and that's what's covered in claim 24 and 26. Okay, there's another, yeah.
So till now, if there was indirect infringement, there was no liability. As in, what was the consequence if it's an indirect?
You had to prove that. Okay, I'll tell you. It's a little bit complicated. To prove indirect infringement, you had to prove that there was a direct infringer somewhere.
Okay.
Providing all that underlying basis.
So in this case, it couldn't be proved. I mean,
in this case, yeah, in the patent that I showed you, yeah, that's right. It couldn't be because they were not providing those computers.
so just because you had that 20 and the other claims which specifically claimed only the server, you're safe. But if those claims were not there,
Correct.
only claim 1 was there, then okay.
That's exactly right.
And but with the new case law, the 2012 thing you were saying, now the definition of indirect infringement has changed.
No, under the new case law, it's just easier to prove the inducement. So let me just let me explain that to you. So to prove inducement, you have to prove that that the inducer knew about the patent, 1, and 2, encourage someone else, actively encourage someone else to infringe the patent. So it's quite a difficult burden to meet, right? So it's not simply that you're just providing some component. It's a little bit more nefarious than that. That you have this whole system set up, and then you go out and encourage others to infringe the patent. That's inducement.
Okay, and he has to know about the existing patent. Means
Correct.
just that it's available in the public domain is considered as knowledge, or
Yes.
it is?
Yes. Yes.
Okay, so it's his job that he has to look up what patents are there and whether I'm infringing or not.
Yeah, but usually, you know, competitors in the same field know each other's patents.
Can the infringer, from a US perspective, get away as an innocent infringer, not knowing a patent?
Yeah.
Can he claim innocent infringer status?
Yes.
In a US federal?
Yes. I mean, he has to prove it. He has to prove it, but yes, you can say, I didn't know about the patent. And that, if you can prove that, then that's a defense, because it's a requirement of the law that you have to know of the patent. Now in the US, as you may know, that there's quite a bit of discovery that takes place. And everybody's supposed to be truthful and honest and produce all of their documents. So, you know, if somebody got an alert, and you see this all the time, you know, companies have alerts on their competitors. You can set it up through Google. Google Alert will tell you anytime any of your competitors, they'll send you an email, right? Anytime your competitors have done something in the news. Well, if you have that set up and your competitor gets a patent, it'll send you an alert saying, okay, now you knew about the patent. Right? So that would probably be enough under US law for somebody to say, well, you knew about the patent, you got a Google alert. You could say, oh, but I didn't follow up on it. I didn't actually download the patent. I didn't look at it. That'll probably be a tough argument because you did know about it.
What's the life of a particular patent?
Life of a patent is 20 years from the earliest filing date.
Filing date.
Filing
not
date.
The
Not
when
the
it-
expiration date.
not the when it was issued or when it was.
Yeah, not the issue date. So the rule changed.
It was 18 years.
17 years from grant.
Okay.
And there's still some patents around that are 17 years from grant. But to be perfectly honest, those are really dwindling in number now. But they changed the rule to make the expiration 20 years from the filing date, from the earliest filing date. And the reason they did that was that what people were doing was they were filing their application. And they just filed continuations after continuations after continuations. Just kind of keep it alive at the patent office. Because the clock wasn't ticking. Then what they would do is they'd wait until the industry that was in the patent scope took off. Then all of a sudden they'd pop up. They used to call it a submarine patent because it was going along under the water until the patent owner decided, hey, you know what? Now I want to get my patent, and I'm going to start suing everybody and waiting. So you wait until the technology catches up, because you may have some very forward-thinking idea. We talked about, instead of one click, one touch, one blink. Okay, well, let's say there's a patent out there on one blink. And let's say 5, 10 years from now, one blink is, that's what everybody does. They look at the screen, there's a retina recognition, you blink and you buy whatever, right? Maybe that happens. Pretty scary if you blink a lot, right? I'm just using it as an example. So let's say there's a patent that covers that. What people did in the past was they would just keep quiet, and they would just keep filing continuation, paying the fees at the patent office, keeping it going, and then popping up suddenly once they see that Samsung and Apple are using this, and then they sue and they say, look, you're infringing my patent. I have a patent on this. So instead, what it is now it's 20 years from the filing date. So if you want to take these continuations and that kind of thing, that's fine. You can still do that, but the clock starts ticking from the time that you file your application.
Now, is there a similar thing for software patents where, like the pharma industry, where you do some minor modification to the patent and you get another 20 years or another?
You could. Those rules, yeah, the rules that you heard about, in this Novartis case, are not specific to any industry. So, let's say you found well, actually, I can give you a concrete example. In that patent that I was showing you, the one that was litigated, remember there was the remote access between the two computers. Well, it turns out, I know this just from litigating this patent, that there's another company out there that what they do is they do that first. But then what they do is they try, that locator server computer on the internet knows where the two ends are. And so it tells them, hey guys, try to connect directly with each other. I know you may be behind a firewall, and you may have a dynamic IP address, and it may not work, but just try it anyway. Maybe it works. And it guesses, depending on what information it knows, that there might be a port open, in the firewall. So it's a UDP protocol way of connecting that sometimes works and sometimes doesn't work, depending on what routers you're using on the system. And so they got a patent for that, and it might work.
So the same company filed it, or there is another company who filed this patent?
It was a different company.
Now, there's a conflict, right? They are using the previous patent's initialization sequence,
Yes.
and then they are improving it.
Yes.
So how do you draw a line there?
Right. So there's no easy answer for that. Generally, getting your own patent does not insulate you from infringing somebody else's patent. So you can still get your own patent. For example, these guys, that improvement, this is hypothetical, but that improvement that they got may be patentable using that protocol to for the two end computers to talk to each other. That may be patentable, but they still may be infringing the patent that I showed you if they're still doing that the more complete connection routine first. Right, so that's a good example of where you can get your own patent on a related subject matter, but still be infringing somebody else's patent.
So
The courts would decide
what do you
that.
do in this
No, the
case?
courts
So
decide
they
that.
Collaborate. These two companies collaborate, and then they put that patent in. Or
Well,
what
they hate each other, so so they're not collaborating. But no, I mean that's right. What they do with it that's a business decision. And so collaboration may have been a better approach, 8, 9 years ago. But at this point, think that ship has sailed.
So, I mean, let's say I have an idea or a process that I want to patent,
Right.
Is there a searching, discovery, enabling mechanism?
Yes, absolutely. Absolutely. Yeah.
Because I want to know today.
You want to know what else is out there.
Yeah.
Yeah, absolutely.
Yeah, I know
So-
my competitors, but
So actually, Google Patents
yeah.
is actually pretty good. It's just google.com/patents.
Okay.
And using certain keywords, you can search through the patent system. You can, if you know who some of the big players are in that particular field, you can search by the company name. You can do all of this at the U.S. Patent Office also. It has its own website. It's a little bit more difficult to use. It's a little bit more technical, but more difficult to use for the same reason. Or you can ask a professional patent searching company to do a search. And it's a bit of an art.
Do you guys do that?
Yeah, we do that. Lots of people do that. That you should have no problem finding somebody to do, a search. And as you might imagine, I mean, the budgets range from, $500 for a simple search, or if it's like a big pharma company, I've got a client who wants us to do a search every 3 days, a comprehensive search. So that adds up every 3 days. And they've got their own reasons for that, for finding out what their competitors are doing in a very critical time frame. Yeah, it's very easily done. You can do it yourself at some level, and then I would recommend, if you're very serious about it, to get a proper search done.
So I have a question here. So the search companies knows this is one pattern, and then the company, who's the client, actually files it. So then who's actually going to, do that?
Yeah, no, I mean, so if you miss something and the patent office finds that one thing that you missed, yeah, I mean, then you're going to have a fight with the patent office. Remember, there's no requirement to do a search. You can just file your application and let the patent office come up with whatever they find. There's no requirement for you to do your own search. Many times people want to do a search, though. This goes back to your question, which is, you truly want to know, do I have something new here or not? So for your own purposes, you want to do a search, just to see what the landscape looks like, but there's no requirement. And in fact, sophisticated companies don't do any search at all. Because you're obligated, if you do a search, you're obligated to tell the patent office that, hey, I did this search, this is what I found. And then they may do an additional search. But you are obligated to tell them about any prior art that you found. And so sophisticated players don't do any prior art search. They just file their patent application. And they say, you know what, patent office, if you find it, great. If you don't find it, even better.
May I just add something to this
Yeah.
question? See, when you undertake a search, the search documents which are available are the documents which are published only. So there is a publication timeline till when patent applications are published. For example, in India, any patent application to get published takes 18 months from the date of filing of the patent application.
Same in
there's-
the US.
Same in the US. So that 18 months gray area always remains there. So you can't say, no one can claim in the world that a patent search is complete ever. That 18 months gray area always remains. So you need to keep on continuously looking up the net or the search engines to find out if any patent in that particular technology scope has been published in that period.
And that's why I was saying it's something of an art,
Yeah.
rather than just a hard and fast black and white kind of thing. So there's like Raghavendra says, I mean, there's a gray area, and at some point if you think you've got it, you just file it, and then see what happens.
I think the important thing to understand is you may have the final output may be the same, okay, but the method of actually doing that may be different, and
Yeah.
hence it will be a new patent.
Yes.
So if you worry too much about just looking at the end product and say, oh, they already have something there, you might actually stymie your business.
That's true. That's true. And that's a very good point. That's why good searching, in the US, for example, if I want to do a chemical search, I know who I want to go to for just a chemical search. I know who I want to go to for just a medical device search. I know who I want to go, and this is just relationships that I have with people that I know are good in certain fields. for exactly the same reason, which is you want to do the right kind of search. You don't want to just look at the end product. Because if you have a method claim, you want somebody to, to have enough granularity in the search that you're able to differentiate not just the end product, but the way you get there too. And at the end of the day, the patent attorneys, like Raghavendra and me, I mean, it's ultimately our responsibility to look at the search results and then determine whether or not there's a way forward or whether there's a problem. I mean, a lot of times I will hire out to a search company to do the search. That may result in, 20, 30, 40, 50, hundreds of search results. And then it's our job, just like you said, to really understand, okay, what's the improvement? It's not the end product, it's the method. So then we have to go through the search results and make sure that we're looking for the right thing. Do you have a question?
Well, I was just thinking of a follow-up step, like, so Raghavendra said that there's that 18-month of gray period, right? So is it a good practice to just put your patent on your website, timestamp it, say that, okay, this is what I thought of here, Is that a good?
No. No, yeah, so it's just like there's, in most countries, there's an absolute novelty requirement, which is you can't disclose it like that. If you've got an invention, an idea, the best thing to do is to get your patent application on file.
Yeah, so I'm saying that I filed, right?
Oh, you file it, yeah.
And then as a follow-up step, I also put it on the website.
Yeah, it's that I mean, once you filed it, then you can do anything you want. I mean,
the other risk is, of course, that you may bring in a lot of imitators because you published it out to a lot.
yes, again, yeah, well, that could be true. But again, if you filed it first,
That could be a business strategy.
yeah, to get other people to yeah. But they won't take, yes, you could patent that. That's your patent, that's your business strategy that we talked about, the business method. Yeah, I mean, once you have the application, that's the most important thing. First to file system in the world. And now the US is pretty much a first to file system also.
The US has gone the Indian way now.
Yeah. Mostly. They're still hanging on to some.
Yeah, some.
Suppose we have a proprietary, we haven't actually thought of patenting it. And now after a few days, actually, somebody is starting very similar thing and he started actually going ahead with the patenting.
Yeah.
Sucks.
Yeah. That's right. That's why we've got the first to file system, which is, it's an encouragement.
So then is that mean that I need to stop using it after turning in the patent?
No.
Is that allowed?
No.